Hey, this is Stephen A. Williams, President and founder of CreditRepairShop.com. I think that you'll find this information very valuable that I'm about to go over with you. I invite you to go and read this court case. It was this individual against Chase Bank, but there was a lot of organizations that actually attached their name to it. And the one that caught my attention was the Chamber of Commerce of the United States of America, and then America's Bankers Association, credit unions, mortgage bankers, all of them kind of wanted to support the defendant, which is Chase Bank USA. And basically, I mean, and you can read through this, but basically, what this is coming down to is the way that they have to investigate when you are disputing the information on your credit reports. Now, this was here was where the big issue came about. Is there there's two dispute processes, which is us as individuals, when we dispute, we are thinking of it as we're disputing it on the bureaus, and that's legal also. Like we're thinking too. But actually, when you read through this, the way that it's defined in the Fair Credit Reporting Act is that when you dispute with the bureaus, you're not actually doing a legal dispute. Even though we probably all thought that we were doing a legal dispute, but this here kind of clarifies it, and they actually state in this brief that people didn't know that it was different, and it took this going all the way to court to make, I guess to kind of clarify and make everyone aware of it. Now, I'm going to read through this one here. This is what kind of really caught my attention because it'll help all of us with any type of disputes that we have, and also kind of clarify if we're making this a legal dispute. And then at the end here, you'll see what I'm kind of talking about, because you could be disputing one thing that's federally legal, but according to your state, the information that you gathered would not override what you see on the federal level or for the federal requirements. And I'll clarify that in a second. All right, so we got here the FCRA's structure, purpose, and history confirm the textual focus of factual accuracy. So the Fair Credit Reporting Agencies, or that's their job. So it says here, Congress explained that the statute was designed to ensure fair and accurate credit reporting because inaccurate credit reports directly impair the efficiency of the banking undermine public confidence, and that's 15 USC 1681A and 1. According to the FCRA's provision, work together to ensure that the information in the consumer's credit report accurately represents her credit worthiness. And they're speaking of this individual in this here. Furnishers have a circumscribed role under the scheme. They always use the scheme. The scheme meaning the way that everything was put together. They must reasonably investigate disputed information to guard against mistakes in a consumer's report, and they must omit certain information from reports following a consumer's direct dispute. 15 USC 1681 S-2. The Bureau's proposed regimen would turn Congress's careful credit reporting scheme into a debt adjudication system, under which consumers may mount impermissible collateral attack against the legal validity of their debt in the guise of the FCRA claim. So this is where it's going to get kind of meaty, I guess, or interesting, more interesting. Suppose a consumer complains about the mortgage balance on her credit report. Furnishers and CRAs reasonably could and are required to investigate whether the amount is accurate, whether it is still owed by the consumer, and the like. But suppose the consumer's complaint is that, and this is where it gets into the legal under debt, complain that her debt is unenforceable under state law because of the state usury statute, which is the statute of limitations. Or it could be because of the amount of the debt was, uh, the interest rate that was charged was unlawful. Anything that basically, just so we don't kind of get everyone confused, is that if something was done illegally by the company in your state, by the state laws, but it's still being reported to the credit reporting agencies who are, uh, they run a mandate under federal law. Would you be able to, number one, sue them? And then number two, where it comes into what we're talking about here, is should that information still be on your credit reports? Because technically, if we're you can show harm by saying, hey, this debt is not proper. I don't owe this debt anymore. It's past the legal statute of limitations, but you're getting harmed, which is something that the credit reporting agencies are not allowed to do, is to have information on your credit reports that will harm you. If you don't owe that debt, are they allowed to keep that information on your credit reports? And then are they required, because uh, which is what they're talking about in this case here, is are they required to remove that information because they're not technically doing your dispute based on a legal definition, which is exactly what got this whole thing in the court. So let's move on. The consumer's proper course of action would be to sue the company, asking the court to issue a declaratory judgment or to enjoin the mortgage obligation. But under the Bureau's regime, the consumer could frame her legal challenges as an inaccurate under the FCRA and sue the furnisher and the reporting agency for failing to reasonably investigate the inaccuracy. And the Bureau's view, furnishers and CRAs would apparently need to substitute for courts and make a judgment about the debts permissible under the state statute of pain and damages and attorney's fees. None of that can be fairly derived from the statute meant to prevent and correct factual reporting mistakes. So, uh, this is going to be something that they're probably going to be making some adjustments on, because if you think about it this way, like really, let's just really dig deep into some thought here. If you have, let's just make it simple. The debt is past the legal statute of limitations for a company to be able to collect or a debt collector to be able to collect. The information is shown on your credit reports, and I've kind of went back and forth with an attorney, and and I stated, you know, that question with him, if and I'm gonna kind of break it into to what the way that I think about it and the way that I've attacked this with for my clients. If a debt collector buys a debt from an original creditor, isn't that debt actually paid off, regardless of what amount they take? Or should they be required to put on there paid for less? Because it is inaccurately showing based on the documents that are going to be sent to you if you request them from the debt collector who purchased the debt. And I believe that this is why they try to put the terminology in their paperwork as assigned or assumed, but it still is a purchase, and they try to hide that information that it is a purchase. But so from my standpoint of the way that I go after this stuff is, if a debt has been purchased by a debt collector, the original creditor should be, according to even what we're showing right here with this lawsuit, remove that information because it's showing inaccurate. It should be a paid account. You have a choice. You could either put the account as paid or you can just remove the account off of there. You could put paid for less, or you could just remove the account off of there. Now let's move over to this one here. You like with this example, you have a mortgage, and then it goes into whatever it went through. That maybe there was some type of law that was broken where they had the amount of interest that they were charging broke the laws in a particular state, but maybe in other states it's not broken. And because the bureaus are under a federal guideline with the Fair Credit Reporting Act, is would they be responsible to have done a full investigation, even on the legal basis? See, the breakdown on this was that they did a factual, quote unquote, factual investigation, which they didn't state exactly how they did their investigation, but they did an investigation which would have been sent to the original creditor or the furnisher. Furnisher comes back, this information is accurate, or maybe they just didn't do anything and the bureau decided because they had put that information in there, it must be accurate. That happens a lot. That happens a lot of the times. And technically, based off of the information that was submitted the first time, the information could be accurate, if unless balances changed and stuff like that, which would and technically make it inaccurate. But for this example, uh, this debt was not going to be able to be enforceable under the state law because of the usury statute, which is the interest that was being charged. So would they be able to continue to keep that information on the individual's credit report? That this is like a very uh, good uh, case, because things like this is going to have to be resolved. Because if you think about it, the FCRA Fair Credit Reporting Act and the way that the bureaus are understanding this is that even if they broke the law with whatever they did with that individual's particular debt, we have nothing to do with it because we're only doing a dispute based on the standard of the information that we receive, not anything looking into the laws of that state, not anything looking at the interest rate that should be legally charged, none of that stuff. All we're doing is reporting information. And that is exactly why credit repair companies exist today, because the way that they are doing all of this stuff when someone is doing a dispute, there's too many gray areas, and that's why there's so much back and forth. Because with one individual, they may choose to remove information, and with another individual that had the same type of circumstance, they decide not to remove the information. And so I'm going to keep my eyes on this because they're going to come back and we're going to see what's going to be the end result on this here. Maybe it was already decided and I just got to find that court document. If you need help with your credit, please visit us at thecreditrepairshop.com. Watch the video, what makes us different, so you can see my 8-point validation process and my 2-phase settlement process. If you need your credit reports and scores, go to the website your3scores.com to grab those. And you can get your TransUnion, Equifax, and Experian reports. If you have debt collectors coming after you, you can grab my 3-pack of letters, statute of limitations letter, debt validation letter, and cease and desist collection activities letter. Those are for free, and I do have a paid version, but you can grab those. If you have debt collectors coming after you in court, we have a program where you can learn to submit your responses, or you can have us do it. Now, I want to also be clear about this because I'm seeing people do things the wrong way, not that get our information because we teach you exactly how to do it, but I've been getting some where individuals, I don't know if they watch some other channels or they just attempted to do it themselves, they just denied everything. You cannot go into a responding to a court summons and saying that you just deny everything and then they produce that one, they produce their affidavit, they produce the one statement or a couple of statements, which is all that is required to prove that you owe a debt unless you make a sufficient defense against just allowing that to be used as proof. So I want to make you aware, don't just make your court responses denying everything. You need to have an affirmative defense based, challenging every aspect of what they're giving you in their court summons. All right, thank you for your time. This is Stephen A. Williams, president and founder of the creditrepairshop.com. Make sure you like this video, share it, post your questions and comments, and subscribe to the channel if you haven't done it already.